You're being sued for consumer debt, which means someone is taking you to court because they say that you owe them money. But wait, what exactly is consumer debt? Consumer debt includes things like credit cards, car loans, student loans, medical debt, and even gym memberships and cell phones. There's good news. Even though you are being sued, you do have rights. This video will help you understand your rights and explain how to assert them. Following the instructions in this video might even help you improve your chances of success. Being sued sounds scary, but there is help. First, let's start with some basic things you'll need to know about consumer debt and what it means to be sued. There are three main ways your court case can end. Dismissed, which means you don't have to pay. A judgment against you, which means you do have to pay. Voluntary settlement, which means you agree to pay a certain amount. This process will involve a few actions by you, such as filing documents with the court, sending documents in the mail, and appearing in person in court. This video will also show you how to respond to a lawsuit, explain the steps in a lawsuit, and how to defend yourself. Remember, the most important thing you can do is take action. This means read all the documents you receive and show up on all court dates. Going to court can be intimidating, but if you understand the basics of your case, you can develop the knowledge to stand up for yourself. Chapter 2. Service. The first thing that happens in a lawsuit is the filing of a complaint by the plaintiff. Receiving the complaint is called being served. The person who serves you is the process server. In many cases, service is not made properly. If it is not made properly, you might be able to have the lawsuit dismissed temporarily, and in some cases, permanently. There are only three ways that you can be properly served. 1. Personal service. The summons and complaint was put in your hands. 2. Substitute service. It was given to a person at your address or work and also mailed to you. 3. If the process server could not find you, they may attach it to your door or to your door at work and also mail it. Some common examples of improper service are 1. Leaving the summons in a different apartment from yours. 2. Sending it to an address where you no longer live. 3. Leaving it in your lobby if you have no doorman. 4. Sending it only by mail. To find out whether you have been served properly and to figure out your options and next steps, you should take action and consult with a legal resource such as CLARO, lawhelp.org, or another legal assistance program. Chapter 3. What to expect in court. There will be many people in the courtroom. The judge sits at the front of the courtroom and is in charge of managing and deciding all cases and issues before the court. The court officer keeps order in the courtroom. In many cases, the court clerk first calls out the cases for the day to check who is there. The clerk will call your case again when it's time for your hearing. You will appear before a judge or talk to a court attorney who must be fair and impartial. Settlement often comes up at court hearings. Consult with CLARO or some other legal assistance program before your court date to learn more about what to expect and what your options are. Chapter 4. Steps in a lawsuit. Burden of proof. Lawsuits have several important steps. 1. The plaintiff starts the lawsuit by filing court papers called a summons and complaint. Then, a process server must serve you with the summons and complaint. 2. After you receive the summons and complaint, you file a document called an answer. This is where you get to list your legal defenses, which are the reasons why the plaintiff should not win. You file your answer with the clerk's office at the court. 3. The next step in the lawsuit is called discovery. During discovery, Each side has the right to see information having to do with the lawsuit, such as account statements and contracts between you and the creditor. 4. After discovery, the case will be resolved in one of several ways. There may be a trial, or one party might try to win the lawsuit without a trial. This is called a motion for summary judgment. In either of these situations, the plaintiff can win only if they prove their case. At every step of the lawsuit, the parties can always decide to end the lawsuit by settling the case and entering into an agreement. If you do not file an answer, or if you do not show up to any court hearing, the plaintiff will win a default judgment. That means that the plaintiff automatically wins the case and can get a judgment against you for the amount they sued you for. Remember the key steps in a lawsuit. 1. The plaintiff starts the lawsuit by filing a summons and complaint and ensuring that it is served on the defendant. 2. The defendant files an answer. 3. Discovery, where both sides request information from each other. 4. Resolution of the case through trial or summary judgment. Settlement, a voluntary agreement between the plaintiff and defendant, can happen at any time during the case. You've been sued, which means you've received a summons and complaint. What does this mean, and what should you do now? The plaintiff is the person or business that brings a case against you. You are the defendant. The summons and complaint is the document where they say you owe them money and why. Once you receive the summons and complaint, it is now your turn to respond. You do this by filing your first document called an answer. The answer is where you get to list your legal defenses. In other words, reasons why the plaintiff should not win or take money from you. In New York City, the court has a special check-off answer form for defendants. That's you. And lawhelp.org has a tool to help you write an answer online. Try to talk to a lawyer through a hotline or a clinic, such as CLARO, before filing your answer. You may also want a lawyer to help you fill out the answer form. When the answer is filed with the court, the clerk at the court will schedule a court date. For example, a credit card company has sued you for not paying bills. It is their job to prove that you owe them the money, and they have to follow the correct legal process. This means they need to sue you within a certain amount of time, serve you with the proper papers and in the proper way, have proof that you actually owe them the money. Remember what you need to do. 1. The answer is your turn to respond to the summons and complaint. 2. The answer needs to be filed within a certain period of time, most likely 20 or 30 days. 3. In the answer, you can list your reasons for not paying. 4. CLARO, Law Help, and other resources can help you with your answer. The summons and complaint will give you a certain amount of time to respond. It could be as little as 20 days. It is very important to file the answer within the time limit specified in the summons and complaint. Remember, take action. If you don't, you could lose the case automatically, which will result in a default judgment. Chapter 6. Defenses. In your answer, you can tell the court your defenses, the reasons why you should either win the lawsuit or pay less than you owe. Here are some of the most common defenses. 1. Improper service. New York State has strict rules about notification of a lawsuit. If you are not properly served, the lawsuit can be temporarily dismissed. 2. Identity theft or mistaken identity. This means that the debt is not yours. You could be the victim of identity theft, or you could have been confused with someone else. Mistaken identity. 3. Standing. If your debt was bought by a third party, also known as a debt buyer, you may have the defense of standing. This means that the debt buyer can't prove that they have the right to collect on that debt. 4. Statute of limitations. The plaintiff has a limited amount of time to file a lawsuit. If this time is already passed, usually 3 or 6 years, the case can be dismissed. 5. Debt paid, dispute the amount. You may have already paid the debt, or you may not agree with the amount that is claimed. Contact CLARO, lawhelp.org, or another legal assistance program to determine if you can use these or other defenses. Chapter 7. Discovery. Discovery is the stage in the lawsuit where the plaintiff and defendant exchange information and documents related to the case. The plaintiff may need certain information from you to prove the case, so they may ask you for documentation, like old bills or bank statements, to see if you have paid off your loan, or they may ask you written questions. It is very important to respond if the plaintiff makes a demand for discovery from you. If you ignore it, you could lose your case. Always be truthful in your responses. These papers are best completed with help from an attorney. You should go to CLARO, lawhelp.org, or another resource for help with discovery. Chapter 8. Endgame. If your case is not dismissed, it can end in one of 3 ways. 1. Trial. A trial is a hearing in court where the parties set forth the facts of the case and the judge makes a decision. CLARO will review what to expect at trial, the steps of the trial, how you can tell your side of the story, and assert your rights. 2. Summary judgment. Summary judgment is when the plaintiff or defendant asks the judge to end the case without trial because they have enough evidence to prove it. You will know that the plaintiff wants to end the case this way when the plaintiff sends you a packet of documents in the mail. Be sure to check the packet for important dates, like when your response is due and the date for the hearing. If you do not respond to the motion for summary judgment, or if you do not show up for the hearing, the plaintiff can automatically win a default judgment against you. It is important that you go to CLARO, lawhelp.org, or another resource for assistance. 3. Settlement. Settlement means that you and the plaintiff work out a deal to resolve your case. Often this means splitting the difference between what the plaintiff is asking for and what you want. You do not have to settle if you don't want to. If you don't settle, your case will continue to summary judgment or trial. Make sure you understand every term in the settlement and agree to terms that you feel are reasonable. You should only settle your case in court. A court attorney or judge should review the settlement agreement with you. Never settle your case in the hallway with just the plaintiff's attorney. Never agree to pay more than what you can. You might be better off going to court and taking your chances. Chapter 9. Default Judgment. If you don't answer the summons and complaint within the required time, you could lose the case automatically because you did not defend it. This is called a default judgment, and you will likely need to pay the debt. If this happens, money can be taken from your wages, also called garnishment. Your bank account can be frozen, and the judgment can show up on your credit report. This is why it is very important to file an answer. What if you never got notice of the lawsuit and there is already a default judgment? Go to court and file a different document called an order to show cause. CLARO, lawhelp.org, and other legal resources can help you prepare this document as well. Remember, 1. If you don't file your answer, you could lose automatically in a default judgment. 2. If you never received a summons and complaint and have a default judgment, you can file an order to show cause to try to undo it. 3. CLARO, lawhelp.org, and other resources can help you file these documents and advise you if you have a default judgment. Chapter 10. Exempt Income. If the plaintiff has won the case, they get a judgment for a certain amount of money. The plaintiff can collect on the judgment by garnishing wages or freezing and taking money from a bank account. But certain kinds of income are exempt or protected from collection. Exempt income includes disability insurance, Social Security, SSI, pensions, child support, unemployment insurance, veterans benefits, and public assistance. Also, if you work, most of your wages are exempt from collection too. It's a good idea to get your benefits directly deposited into a separate bank account, and do not mix exempt income with other kinds of income in your account. This way, if you do lose the case, it is easy for the bank to see that the money in your account is exempt. Consult with CLARO, lawhelp.org, or some other legal assistance program to determine if you have exempt income. Chapter 11. Resources. The most important rule of all is to take action. No matter where you are in the process, be proactive. If you are getting debt collection calls, if you receive a complaint, or if you find that your wages are being garnished, you can take action. At any point, there are resources that may be able to help you.